July, November is relevant. The reason that the testimony regarding what happened at the November hearing is relevant is that in a conversation that Mr. Sledge had on November 19th, 2015, that was served, and that the court said we could not introduce unless he testified inconsistently. Mr. Sledge said specifically, after talking about getting money for a bond, which is not what we want to get into, at 3 minutes and 18 seconds into the phone call, he says, them folks threw Shannon under the bus, man. That and Summer D ain't right either, boy. And the girl said, you're lying. And Sledge says, man, he told on that boy, man. The young person with whom he is speaking says, he said, 2 people wrote a statement on you. She's talking about the detective, I believe. And the girl says, Woody. And Mr. Sledge says, nobody wrote a statement on me. One dude wrote a number. And the girl says, one witness saw you there. He says, he being Mr. Sledge says, it's the number 2 witness, and Woody and Lil D never said nothing about me. They said it about Shannon. That's why they dismissed it. We're not trying to get that part in. The girl says, whoever they came forward October 19th, Sledge says, them folks, he references why it took 9.5 months to come forward, whatever, and the judge, Judge Atkinson, he talks a little about him. We're not getting into that. Mr. Sledge then says the first case got switched, but the body didn't. Basically, he's saying that the judge found no probable cause for him on the murder of Mr. Thomas. The girl references the fact that they can indict it. They talk about him being able to dismiss it. The young woman asked, what did they say about Shannon and 30 Deep? 30 Deep D, meaning Mr. Garlington. Mr. Sledge says, man, 30 Deep brought his name up. Booty brought his name up. I knew YSL D. And I put 2 and 2 together. He references something about Shannon's lawyer. And the girl said, someone from YSL said, Monk, he said that. I was telling OG, he said either D or DK. He then says,
oh my gosh, it's going to be a long morning argument.
I'm looking for the literal quote, but I'm going to summarize it, the part that is relevant.
Oh,
He
no.
says that Lil D's not right. He knows that it's Lil D. They didn't call his name. They called him witness number 2. He knows it's Lil D because that witness told them about all of us meeting up at the condo after, not his words, but he's saying after Donovan Thomas's murder. He told them about all of us meeting there. The only person that could have done that was Lil D. On the stand, while Mr. Sled is talking, he says, well, the court remembers that he referenced going to Mr. Williams' condo and only seeing Mr. Williams and DLB, and all that was happening was that they were working on the song Da Vinci. And then they left to go to another condo so Mr. Williams could grab some jewelry. And then maybe while he was there, he got a call from Mr. Copeland. Mr. Copeland came over, he can't remember, but he doesn't remember who all was there or what, who all might have been there. But there really wasn't a meeting up there. And on the phone call, the reason that he surmises that it was Quindarius Zachary who told police the information they were able to share at his preliminary hearing is because the details that Quindarius Zachary gave were details that only Quindarius Zachary would have known, because drawing the inference from what he is saying, Quindarius Zachary was there, he was there, the rest of them were there. Nobody else would have known. They were all there but Quindarius Zachary. So him saying, hearing what he heard at his preliminary hearing is what led him to surmise that it was Quindarius Zachary who had told. And Quindarius Zachary had not told him, Antonio Sledge, anything about what he told the police. He just told the police. And then the police, trying to protect Quindarius Zachary, uses witness number 2. So those links are necessary in order for me to be able to put before the jury the fact that, one, Mr. Sledge and other people that they will later hear about were in fact meeting up. They did meet up at the condo, just like Mr. Sledge said in his factual acknowledgments. And what he is saying on the stand now is wholly different than what he said when he took his plea back in 2022. So it's relevant. I mean, obviously the bar for relevance is low. This is very relevant. It took a few steps to get to why, but that is why I was saying I was laying the foundation for more evidence that was going to come in.
Okay, well, I think that it might be relevant if you can find me like his actual statements where he is saying essentially there had to be little d because he told about us meeting up at the condo, as if, he is saying, I know from my own knowledge being there that this could only have been him because he would be the only other person who knows about it. That part might be relevant because it is inconsistent with what he said on the stand about the only people I knew at the condo were maybe Jeffrey and the people who came with me, which was my baby's mother and my baby. But all of getting it to that,
I don't need all of it. When I said what happened at the prelim, I did not want, and it was an inartful way to elicit that, and I can be more precise. I asked the court for permission so that the court knows exactly what I'm talking about, to just play that snippet. We have a jail call pulled up, and we have a timestamp as well, that we can play for the court, if the court will allow us to play it for the court.
I'll listen.
Guys, this is going to be a long little morning. Shout out to Mrs. Kim's. Good morning, Kat and Chad. Have a good day. Have a wonderful day.
Any knowledge of any members of YSL speaking to the police? That is something else that you talked about yesterday. That was a question I think that I asked, and not as specific as the stuff that I just said, but.
So Tommy will.
Oh, we need these positive vibes. Thank you so much,
Also,
Mrs. Kim's.
In this part that the court is going to hear, he says he put it together because that witness that they did not name was buying guns for people within YSL. Quindarius Zachary, we all know, is the one who was straw purchasing for them. And in fact, he was sentenced federally for straw purchasing. He was the one that purchased the gun.
I get so mad when she speaks factually. She can speak factually that he was straw purchasing because he has a conviction. But to say for them, which is vague, you're not identifying who them is. And you're saying we know he did that for them. You're factually asserting instead of saying we believe the evidence will show. The evidence will show. She's doing the thing she always does. I hate that. I hate that. I hate that.
One of the ones that the witness had, in the video that the jury has already seen. And Mr. Sledge in this jail call says he knew it was, Pandaria Zachary because they referenced that witness was buying guns for YSL. So we're gonna start at 3 minutes
Your Honor.
and 12. We're gonna start.
Well,
Before you play it, I'll hear what he has to say,
Thank you,
but
Your
finish what you're saying.
We're gonna start, the one segment, the first segment of this jail call from November 19th, 2015, that we're gonna play is 3 minutes and 12 seconds in, and then we're gonna stop it and play other portions, and I'll, cede the floor to Mr. Schardt before we start that process.
Okay, and do I have a transcript of these calls somewhere? I do, right? Or no?
no.
Okay, all right, yes, sir.
Respectfully, I'm lost. The putting things together from what was said at a prelim, that was said about my client at a prelim, all of that it's preposterous to me that the state would be attempting to get into any of this. And this seems to be becoming very complicated for something that should be very simple. There's no putting it together. There's no, I realize little D told. There's none of that, because I'm going to tell, I'm putting everyone on notice right now. I don't know what Mr. Zachary is going to do, but if there is elicited testimony about my client, stuff about what Mr. Zachary said about my client or to the police or at my client's prelim or at a prelim in general, I am moving for a mistrial. I am of the opinion that the state will have goaded me. I'm putting them on notice. Don't do that. And it's they're trying to backdoor testimony because they don't know if Mr. Zachary is going to testify or not. Now, if it's just a matter,
Yes, he's sick.
Mr. Sledge, you said you don't remember who was at the condo. Didn't you say to your girlfriend or whatever she was, wife, fiance, that Mr. Zachary was at the condo on the night of January 10th, 2015? Didn't you tell her that on a jail call? And then if he denies it, then we play the little snippet where he says that one thing, then I guess that makes sense. But I don't know why we're getting into, I figured out he was the witness. This is what he said. You know, this is what he said about me. This is what he said about Shannon. He must have known these details. Why are we doing this?
May I respond, Your Honor?
No,
Two things.
please.
One, this notion of goading into a mistrial and don't do something is not anything that I can respond to, because that is wholly wrong. The fact is, every defendant knows that the state has a good faith basis for putting forth the knowledge that Mr. Sledge had regarding what Mr. Zachary said. Mr. Schart's words to the court seem to suggest that for some reason he believes Mr. Zachary, we won't be able to procure him. He's under subpoena. They know that he is, and we have served him, and we have every intention that he will be here. He is not, he's out of the hospital, I'll put it that way. We have the statement that Mr. Zachary has given to the police. We have served it. They know what he said. Mr. Schardt is well aware what Mr. Zachary said about his client. The reason that what Mr. Sledge tells his girlfriend is relevant, and the reason that there are those steps that have to be taken, is that Mr. Sledge, as I stated earlier, surmises, he realizes who it is because of the facts that Mr. Zachary shared with police, that police then told about under the label of witness number 2 at the preliminary hearing. Mr. Sledge doesn't say Zachary lied. Mr. Sledge was there. Mr. Sledge has actually said he was there. Mr. Sledge is the one that gave the state, and unfortunately we may have to impeach him on that with other evidence. He's the one that gave us the statement.
If you need to impeach him and you're already planning to impeach him, how are you saying that you're going to use anything from him to show that it's knowledge, that it's known? This isn't compatible. Your argument is not compatible.
We met up and Thug gave us money to lay low. All of that aside, I have no words for the whole goading stuff because that's not what we're doing. We would object if Mr. Schardt even makes
Okay,
one.
let's just get to what it is that he, and I don't know why the part about guns is relevant. If you are telling me that he essentially says, I know that's little D because of what he said about us meeting up that only he could have said. That's the part I'd like to hear. And that's the part that might be admissible as a prior inconsistent statement. So let's hear that part.
To all this, she didn't address what she needs to address. Hot mic.
And I guess the guns part, I mean, I guess he did say he never sold. He doesn't know if Zachary's selling anybody guns. So, you know, I guess that could be a second prior inconsistent statement. Yes.
I don't know. I'm not in Mr. Sledge's mind. I don't know his reasons for it, but that was an inartful question from the state. Because
Inartful is the
I
word
don't
of the day.
think the truth is that Mr. Zachary has sold guns to different alleged members of YSL. I think the allegation is that Mr. Zachary was a straw purchaser. I wouldn't call that selling a gun.
Yeah. So, I mean, it may be that if you want to get that in, you need to ask different, more specific questions. But let me hear the part about the meeting up,
Yes,
whatever he says about that.
we're going to start at 1321. Is it playing? We're starting a little bit before.
About the whole situation, I like really like they told them, they said Noah was there.
You know, Vera said he went well, you know what's going on.
Yeah, you know what I'm saying. The whole situation, whoever witness number one is, they tried to know it. Cause he say, you remember when we talked on the phone, he's like, boy, you didn't know nothing about it. You was in the blind. They told them folks deep. After Slug got killed, all of them met up together and went down over house. Them made that word. That's how you know it's deep.
Which so when y'all ready to what Shannon said.
But that cause they sent me back before Shannon, cause Shannon was still up, so they
So the old boy's house that we believe he is talking about is Jeffrey Williams' house. That is the only house that he has testified that he went to. We have Mr. Zachary saying they met up at Jeffrey Williams' house. We have other people. It's not like we do not have a good faith basis for knowing and realizing that's who they're talking about because Mr. Copeland,
Anyway, that's witness one, not witness two.
my apologies.
Anyway.
Why is my client's name coming up in that conversation? There's no inconsistent statement that would lead to admissibility.
Why is that in the courtroom anyway? Is that somebody, what? Is that somebody who has a Rule 22?
Go back up.
Whose is it?
So,
Huh?
The second part, Judge, just to orient the court, there is at 5, we wanted to play the part that the court asked about what he said about the witness, but to orient the court as to the question posed just now, we would need to go to 557 where Mr. Sledge references it being Lil D. So if we could
hang on just a minute, because we got to deal with this one first. So I think it sounds to me like they're saying, here's what happened, and we know X, Y, and Z because we were there. And so I guess the reference to Shannon is because he knows Shannon was there, and he has said on the stand, I didn't know anybody other than
No.
Jeffrey and, okay, what?
I think, I don't have a transcript, but what I heard that little snippet to say is little D, and of course we have two little Ds. I'm going to assume for the purposes of this statement that he's talking about Mr. Zachary, was saying things at the condo and putting Shannon there, meaning, and he also references Nard, who's Demise McMullen, there being the murder scene.
There being the murder scene?
Yes.
Honest to God, a transcript would really help because it's hard to tell what everybody's saying.
Our transcript is of the quality. and
Okay, but y'all can retranscribe little snippets. Somebody who knows what the content is, like what is being talked about. It's not, it's not that hard to do.
We have not a formal transcript. We have what is being talked about in timestamp form that we can give to the court.
Okay, so is it your understanding that they're talking about the murder scene, or they're talking about the condo right there, what we just heard?
They were talking about the condo when he said that they met up at old boy's house.
All right, if we don't even
We
know
st-
what's
we-
being said, then
We
I
do
don't
know
know.
what
Trial
is
waiting
being
to
said,
happen.
Your Honor. It is
What?
not.
This is a mistrial waiting to happen.
Your Honor, if I may.
Potentially. Go ahead.
Judge, we were playing the clip. We put a portion in about Nard. We're not trying to get in anything about the murder scene or Nard. We are not going to cause a mistrial. We are giving to the court the portions of the call that we wish to play. I'm being specific about the portion because we started the clip a second before where someone was able to pick up Nard and make a whole separate argument about the murder scene does not take away the importance of the portion we're presenting to the court that we need to play, which is that I know it's Lil D because he told the police about us all meeting up at old boy's house.
She just filled
after
in
Nutt
the
got
words.
killed. So nobody is trying to put in anything about the murder scene. Nobody is trying to put in anything about that.
So let me hear the part you actually want to play. Just the part you want to play.
Yeah, don't play the wrong part again.
So, Your Honor, is it at this time that we're allowed to play the portion I told you that gave some context to we had a specific part the court just asked us to play that we
Play that
played.
part.
There is a part before that. We have said
I don't want the part before it. I want to hear what it exactly and only what you want to play before the jury, because that's what I need to rule on.
Yes, Your Honor.
Ah, Bama Rose says, Judge, the state's math is 1 hour equals 1 day. Be prepared. We're going to take the morning on this whole thing. Like, please have love. Stop questioning witnesses and handling this. I thought this morning was going to be somewhat a break of Love doing this long-winded questioning, but it's just her making long-winded arguments.
Nobody can hear it. Okay, they're just trying to figure out where to start. Why do we have food in court again? I didn't change that rule. No food in court. Somebody please retrieve the banana and take it back to the back.
Oh my god, the Mario Kart emojis would go fire right now. with the banana.
Well, you can't have food in court either. We're in court right now. We're not on a recess. We're not at lunch. Put it back in your briefcase. That's fine. I don't care about a covered drink. That's fine. It's food.
This number one is this I know it deep. Cause he say, you remember when we talked on the phone, he's like, well, you didn't know nothing about it. You was in the blind.
Mm-hmm.
They told them folks deep. After Slug got killed, all of us met up together and went down Old Brown. Them made that word. That's how you know it's deep.
That's,
Perfect.
and John, that's the end of that portion.
Okay. If there is an inconsistent statement, this is where we're at, as far as I can tell. Mr. Sledge testified that he couldn't exactly remember who was at the condo. Okay. If there is an inconsistent statement that says D, which is of course complicated because there's two D's, is at the condo that night, then it seems to me it would be easier and cleaner if we just had him refresh his recollection. But that's how I know he told. That is, why is that coming in?
Right. I'm not sure why that's relevant.
Judge, the reason that is relevant it's two things I want to respond to. The notion about we don't know which one it is. He makes a distinction.
Let's
in the
not worry
call.
about we don't know which one it is.
Okay, so the reason that it is relevant is because we know, Mr. Schardt knows, everyone knows that what Quindarius Zachary told the police is specific information that will be presented.
Let's get to, how about if you ask Mr. Sledge specifically on the stand? You said the only people you remembered were blah, blah. Didn't you tell whoever this is, your girlfriend, didn't y'all discuss the fact that he was also there or something to that effect? And then if he says no, then you confront him with this prior inconsistent statement, which he needs to listen to first without the jury hearing. And then he can say, oh yeah, actually I did. And if he still says, I don't know, then you can play that little part.
Also, Your Honor, we feel it is important that the jury hear what he says, because he said Lil D told on them folks. He told them folks. Earlier in the call, the portion we've not played, there's a distinction. I know I'll get there. The reason that is important is because he starts out talking about people telling. Yesterday, the court heard him say.
Yes, I don't want to go through all of that again. I can follow the argument, but he does not say told on us.
No, he says,
He
told
says
them folks.
told.
Them folks.
Yeah,
Yes.
which doesn't mean, Lord have mercy. We heard Kenneth Copeland say, I told 100 different versions of things. Telling somebody something doesn't mean you're telling on them or you're ratting them out or anything. And I know the state want it to be that, but you don't necessarily get that from, if you have something that says XYZ told on us, then yeah.
Your Honor, if Miss Hilton and I were the only two people in a room where I ate someone's crackers, and Miss Hilton comes out and she tells my boss, Miss Love ate those crackers. And then my boss announces to the world, Miss Love, you are dismissed because you ate so-and-so's crackers. And I say, well, I know it was Miss Hilton who told, because
yes, that is one version of how something like that could go down. But Miss Hilton could also walk out and say, Miss Love ate those crackers, and there weren't even any crackers in there to begin with, in which case she is not telling on you. So it is an argument, but it is not established.
Yo, okay, I love that Whitaker agrees with Woody's definition of snitching versus finessing. This is what she's adopting Kenneth Copeland's argument and explaining that to Love again and again and again.
Is just because you think that's what he means when he says that.
Your Honor, I understand the court's position, and I would just say that if the argument has been relevance, the very fact that we're here at the place where there is an argument that the court sees on either side makes it, to me, very apparent.
I said that you can get in the part about what I just, that little snippet you just played, if you confront him with it and he says, yeah, I totally still cannot remember him being there.
And just for the record, Your Honor, the evidence rules do not require that I play it for him before I impeach him with it. So in other words, he does not have to hear it. The rules, I will find it for the court. It's very specific.
Well, if you can recall it to his attention specifically enough without him hearing it, fine. But he has to be confronted with the prior allegedly inconsistent statement and given an opportunity to explain it or deny it or whatever, and then it can come in.
And so telling him what he told her at this time on this call.
But you need to be careful about what you say when you are recalling that to his attention, because we do not need to get into this happened at a preliminary hearing, or you heard it from a police officer who was giving probable cause or anything like that. This is just, he somehow knows that this person has said that and he's saying, oh yeah, it had to be him because he was there or whatever. Okay.
Your Honor, I want to make sure I stay within what the court is requiring that I do. So, Your Honor, the fact that Mr. Sledge hears a rendition of an account from a witness one that Mr. Sledge recognizes, in his opinion, came from Lil D. Does not the rendition?
What you claim to be trying to get in is that he said something to his girlfriend that makes it clear that he knew that Lil D was there.
When you say you're talking about Mr. Sledge saying something to me. What I'm trying to get in, Your Honor, is the fact that Mr. Sledge, in telling his girlfriend he knows Lil D was the one that told, knows it because he said he told police that we all met up at old boy's house after Nut was killed. That part, we all met up at old boy's house after Nut was killed, is the part that I'm talking about. And earlier in the call, and we don't even have to, I won't even touch the call before whatever break the court has, if it is not resolved, obviously. But earlier, he is talking about defendant Stillwell, and he is talking about at 5 minutes and.
This is the part we haven't gotten to yet.
Because
I'm willing to listen to that also. I'm just trying to resolve this one first.
Your Honor.
Yes, Your Honor.
The state began this whole discussion saying that they want to impeach Mr. Sledge with a prior statement because he said that he didn't recall who was there. That's what this whole thing was about. Now we're talking about he told. And I'm going to go back to the same thing because I don't understand what's confusing about this. He was at the whole part about yesterday where Mr. Sledge said, no one told me what they told the police.
Right.
Mr. Sledge was at a prelim.
I know, which is why I'm saying she can't get into that part.
But it's not the prelim itself. It's also clear that he got this information from the officer testifying at a prelim.
Right, which is not inconsistent with him saying, nobody talked to me about what they said to the police. I said that yesterday.
Okay, I got you.
I got you too. I mean, I understand what the issues are.
Well,
All right, so let's listen to the second one.
Good to see you, Amy. Thank you so much.
We're starting at 5 minutes
Look at them all texting furiously. They're like, do.
Portion where if we don't clip it out, he's saying that they threw out his charges. We will not play that. We will not get into any of that. We will not get into what did they say about Shannon and 30D. We're not getting into that.
Go to the part you are getting
It's about 3 seconds.
into. Okay.
You might have to go back. Go ahead. Can we join? Can we be allowed in Zoom? Here we go.
Jay, this is hilarious. The jury has already decided the state is guilty. Can you imagine a returned verdict form that says the state is guilty?
Because I put 2 and 2 together. Because Shannon lawyer.
So then when he said somebody from YSL, they stood that. I mean, he said they saved Moon. He said they had another person they saved Moon. He said that, and I was telling OG. He said either D or DK. I was like, I don't think it's DK.
It's D, man, because they said, you know, Shannon got a paid lawyer. So Shannon's lawyer like, yeah. So Shannon's lawyer like, how could a person that they saying is buying guns from the YSL make a statement on? See, they were trying to hide these names, but he said that, and that's how I know it.
No.
Look at Doug. Look at Doug.
Okay, we don't have a problem with that.
Okay, so